Please be seated. Back on the record on case number 19, CR 586 A and B, State of Ohio versus Daniel Groves and State of Ohio versus Jessica Groves. Counsel and the parties are present in the courtroom. Jury, it's 8:15. The jury's been ordered to return to the jury room at 8:30. Jury is not in the courtroom at this time. I wanted to have a short hearing here this morning. I discussed this with counsel last night so that they could, defense counsel could discuss this with their clients. The state has rested. Here shortly, the jury will return to the courtroom. I'll allow the jury to again rest in front of the jury since they weren't privy to those conversations after they left the courtroom yesterday. And then the defense will begin their presentation of evidence in this matter. Mr. Stratton, as to the defendant Jessica Groves, has she made any decision at this point if she intends to testify in this matter?
She intends to testify, Your Honor.
All right. Now, Ms. Groves, I've gone over some of this stuff with you here a few days ago, but I want to talk to you again to make sure you understand. You have a right to testify if you wish to, but you also have a constitutional right not to testify if you don't want to. Now, this conversation is a little different because earlier this week we had the conversation that you intended to testify. You wanted to make that decision early. I believe you made that decision knowing that your lawyer would say what he said during the opening statement. Is that correct? All right. But I want you to know, and I told you at that time, that you don't have to make that decision until it's time to present your case in this matter, which will be here in about 15 minutes. Do you understand that you have a constitutional right, even now, not to testify? The Constitution protects you on that. It also protects your right to testify if you choose to. Do you understand that?
Yes, sir.
Do you also understand that if you chose not to testify, I would instruct the jury that they weren't to consider that for any purpose because that's your constitutional right. And I would also remind the jury that the opening statements are not evidence in this matter and they're only to consider them for the benefit it is to them in viewing the actual evidence. Do you understand that?
Yes, sir.
Because what I'm telling you is if you change your mind, it's not too late to change your mind. Do you understand that?
I do.
All right. And do you have any questions for me about this issue?
No, sir.
With all of this in mind, do you still intend to testify in this matter?
Yes, I do.
All right. Now, Ms. Scott, I understand that Mr. Stratton's going to go first with his presentation of evidence, and then you will present the evidence on behalf of the defendant, Daniel Groves. Has he indicated if he intends to testify in this matter?
Your Honor, at this time, my client does indicate that he is going to testify in his part of the matter.
Mr. Groves, I've had these conversations. You've been here while I had these conversations with Mrs. Groves. Do you understand likewise that you have a constitutional right not to testify in this matter? Do you understand that?
Yes, sir, I do.
Do you also understand that if you chose not to testify, that I would instruct the jury that they're not to consider that for any purpose? Do you understand that?
Yes, sir, I do.
I will tell you, my purpose in going over this with you here is not to try to tell you you should or shouldn't testify. My only purpose in doing this is to make sure that you understand what your options are and what your rights are. Okay?
I completely understand, Your Honor.
Have you had an opportunity to discuss this with your attorney?
Yes, I have.
Now, sir, if you choose to testify, there is, I understand that you do have a previous conviction for theft. Do you understand that if you testify that the state would then be able to question you about that past criminal offense so that the jury could consider that in determining what weight or what credibility to give your testimony? Do you understand that?
Yes, sir, I do.
Do you also understand that if you didn't testify, the jury wouldn't be privy to that information because it wouldn't be relevant to these proceedings? Do you understand that?
Yes, Your Honor, I do.
Do you have any questions for me about this issue that we've talked about?
No, sir, I don't.
This time, I am going to find that both defendants have understand their constitutional right to testify or not to testify, that they understand the procedures that would apply, that their rights would be protected if they chose not to testify. I would tell both of you, until you take the witness stand, you can change your mind. You need to let your lawyer know. But once you take the stand, it would be past that. You both understand that?
Yes, Your Honor.
Yes, Your Honor.
All right. Anything further from the state on this issue?
No, Your Honor. Thank you.
Mr. Stratton, anything further from the defense on this issue?
No, Your Honor.
Ms. Scott?
Not at this time, Your Honor. Thank you.
Now, we went through exhibits yesterday. One of the exhibits that we had discussed was State's Exhibit 78, which was a visitation booth recorded conversation. I believe the disc that was marking the courtroom had multiple conversations that were not played for the jury. I understand that last night the state has substituted 78 to include only the call that was played before the jury. Is that correct, Ms. Hutchinson?
It is, Your Honor.
Has the defense had an opportunity to review that exhibit?
We have, Your Honor.
Yes, Your Honor.
Is the defense satisfied that what is now on the substituted State's Exhibit 78 is what was played for the jury?
We are so satisfied.
Yes, Your Honor, no objection.
All right. My earlier conditional admission of 78 will now be a full admission. Anything further before we bring the jury down?
No, Your Honor.
Not at this time, Your Honor. Thank you.
State?
No, Your Honor.
Court is in recess.